Hello, good afternoon, and welcome to today's webinar on IR35. I'm delighted to welcome all of our guests today. Thank you very much for everyone that's joined the webinar. We really appreciate it. I'm really pleased to welcome as our guest speakers today, Julia Kermode. Julia, welcome. So lovely to see you. And Gareth Walls. Gareth, you're welcome and so lovely to see you also. Julia is the founder and director at iWork, which is an organization that champions independent work and independent workers. Julia is also the host of a very successful podcast, which I've been on myself and I highly recommend it. Julia, it was a very enjoyable experience. I've had the pleasure of getting to know Julia over the years with her work at the FCSA prior to iWork. And for anyone that knows or heard of Julia, she's a tireless an effective advocate when it comes to the championing of workers' rights. So Julia, warm welcome. I don't think it's an IR35 webinar without you on it, so I'm really pleased to have you here. So thank you again. Also a warm welcome and introduction to Gareth Walls. So Gareth is the employment partner and head of employment at A&L Goodbody, which is our external legal counsel. I've got to know Gareth well over the years. Gareth is a specialist, as you would expect, in all areas of employment law, with a particular expertise in IR35, employer-employee dispute resolution, 2P or 2Pay, I can never pronounce it correctly, the Modern Slavery Act, and a whole host of other employment-related matters. Gareth, great to see you. Again, it wouldn't be the CXC IR35 webinar without you, and really great to have you both on. My name in brief is Conor Heaney. I'm the Managing Director here at CXC Global EMEA. We compliantly connect talent with opportunities. So we'll move straight into our discussion points. Again, thanks everyone for joining us today. So we're going to cover a number of topics. For many of you, I'm sure you're all familiar with IR35, but as we'll see and hear during the course of the webinar, a lot of organizations are really still grappling with IR35. What is it? How do they manage it? How do they manage the risks? How do they set themselves up for success? How do they protect their business while still engaging independent workers or PSC workers compliantly? We're also going to look at some of those problems and challenges that we've seen in the market since IR35 went live in April of this year. There's very little case law on IR35 since the post-go live, but we're going to look at some recent cases that have come out of the UK government. So the Department Work of Pensions and also the Home Office, some of the penalties and back taxes they've had to pay. Also want to explore the much vaunted HMRC soft landing, and really what we're saying here is it to be believed? And then we want to leave you, our audience, with some practical tips in terms of how to best manage and mitigate IR35 risk. But I think it's fair to say, before we get into it, the launch and implementation of IR35 in the private sector has been problematic, to say the least. I think it's been very, very difficult for even the most mature organizations that have been planning for this for years, and then other organizations that are perhaps less mature, they're struggling with it. So hopefully after today's webinar, we'll be able to set up some of you and your organizations for success. So some brief housekeeping. We are recording today's webinar. Again, thank you very much for joining it. Please, would you do me the courtesy of keeping your lines on mute? We will be having a question and answer about 45 minutes into it. Connor Lavelle from our marketing team here in Europe is managing the chat function. So please direct your questions into the chat. So guys, thanks again for joining us. If we could go back to the discussion points, Connor, thank you very much. So Gareth, we've given the intro, we've given you the warm welcome. We're really looking forward to hearing what you have to say. As everyone knows on the call, Gareth is an employment lawyer in the UK and Northern Ireland. So please don't take what he has to say as binding legal advice or any legal advice. It's merely his opinion based on his expertise and experience. But hopefully you'll get some good tips from that. So Gareth, what is IR35 in its pop quiz form? Can you give us the 5-minute headline and what are the obligations on organizations?
Sure. Thank you, Connor. So look, good morning, everybody. It's good to be with you again. Much vexed subject matter. I enjoyed the introduction that Connor gave me as being an expert in IR35, because one thing that I'm seeing and I'm very clear about is as the weeks go by, it doesn't seem that anybody is a genuine expert in this. There are so many inconsistencies in terms of approach and understanding on all sides of the house. And we'll explore that a little later, but it just is an exceptionally fraught arena that we're working within. But let's go back a couple of steps. So what is IR35? Well, I suppose the first thing to say is it's nothing new. IR35 is effectively a form of UK tax legislation, and it is designed to broadly correctly assess each individual worker off payroll or otherwise who deems themselves a consultant, for example. There's a whole plethora of terminology. But what it is seeking to do is to try and ensure that the correct levels of taxation are paid, and that where an individual post-April 2021 is IR35 bound or caught, then they go on payroll in a way that they haven't previously. So whereas organizations might previously have had employees, workers in the general sense, and we're all familiar with that, and tax deductions to be made, IR35, as extended in April 2021, seeks to make sure that there's a further category of individual on payroll for tax purposes, and this is your PSC, or indeed some terminology, this is your single person corporate vehicle. We will look into all of that in due course, but part of the difficulty, I think, with IR35 is that actually it should have been introduced in April 2020, but because of pandemic, mostly, it was extended and kicked out to April 2021 for the private sector. One would have anticipated that notwithstanding the pandemic, there would have been an awful lot of appropriate HMRC UK government guidance to sit alongside the step change in the legislative framework to assist employers and to assist individuals checking their own status in light of this. But in actual fact, between 2020 and 2021 and April go live, there really wasn't very much of that at all. Pandemic and Brexit outflow presumably was the priority for the government. That is fine. But on the other hand, what we're seeing even in the first few months post-April is an awful lot of inconsistency of approach and confusion. And that is true for UK-based organizations who solely use UK workers, employees, and PS workers or single person corporate vehicle consultants. But it is even more so the case for any organization with an international presence. Trying to navigate the IR35 UK tax regime is proving exceptionally difficult. Having said that, it's with us, it's going to be with us. And I think certainly Julia, Connor, and myself in prepping for this and having a look at it, even given the sort of the next steps that we've got, it's looking into the problems and the challenges, and there are many. But fundamentally, it should be a relatively straightforward tax regime. It should be supported by what we will reference throughout this talk as the CEST tool, which again is a UK HMRC tool, which is supposed to assist us in working out tax determinations and status determinations. And status determinations themselves are another it's a phrase that we're going to be using and referencing a lot, but that is the outflow of the change in IR35 in April 2021. The liability for making an assessment does not sit with the individual as it might have in the past for their tax returns. It now sits with the end user. It sits with the employer, small e, of the service user. So that is another big piece to this. Not only is there an issue in terms of doing an assessment in relation to the individual and working out whether they are payroll or off payroll, the liability for that decision lies with us. And that's one of the biggest issues I think that we're all facing. Is that probably enough, Connor?
It is, but listen, Gareth, this is fascinating stuff. And if someone had have asked me this 5 years ago, would I've ever found, contractor taxation fascinating, I would have said no, but it really is, because With the IR35 regime, you've essentially got taxation without representation, right? If you think about it from the worker's point of view, that in some cases they're essentially paying employee-related taxation if they're deemed inside IR35, but yet they've got no rights as an employee. Essentially, I know there is mechanisms that they can take, and we can come on to that later. But fundamentally, that's my problem with it. But I think it's small beer, actually, in terms of what we're going to consider in a moment. So we're going to look at the challenges and some of the problems that we've seen with the adoption of IR35. And if I think about some of the anticipated challenges before it went live, we talked about contractor flight to other markets. We talked about rate inflation to the end client. We talked about the difficulty of using the CEST or other tools in the marketplace to accurately assess whether a worker was inside or outside IR35. We talked about organizational readiness for this change. Where if they were engaging the workers directly, how did they pay an invoice to a contractor? We talked about blanket bans and organizations, mainly in the banking and financial services sector, saying, you know what, we're not engaging PSC workers anymore, and we're happy to stand over that as a policy decision and the impact of that. I think they were some of the anticipated and likely known challenges that we would have expected and faced. And I think in our experience here at CXC as practitioners and advisors to organizations around that, we've certainly seen that challenge, those set of challenges, but we've seen some other challenges that I'm going to come on to in a second. I can't wait to hear from you, Julia, in particular from the worker perspective, and also organizations, and likewise from you, Gareth. But one of the things that we're seeing is that the CEST tool does not work, right? It often produces uncertain determinations, right? That's not really helpful if you want to categorize a worker as inside or outside IR35. What the hell do you do? What is your defense if that is the case and you engage a worker? The other thing is that we're seeing within organizations a lack of understanding at the hiring manager or user level in terms of when a worker is deemed inside IR35. There's almost this push and pull within organizations between hiring managers essentially seeking to jimmy the system, if you like, and put a worker that should be inside IR35 outside IR35, and then you've got the procurement and the HR and the other legal sponsors in the business saying, well, whoa, hang on a second, that's not really how we want to be doing things here. So, Julia, from your perspective, there's some of the challenges that we're seeing here at CXC amongst our clients and new and existing. But what are you seeing, Julia? Would you be able to share that, please?
Yeah, of course. So, so much of what you said really resonates with kind of my experience of the off payroll changes. And when you're saying about what you said earlier in relation to the unfairness, if you like, of being taxed as an employee but not receiving employee benefits or rights of employment. The vast majority of contractors that are found inside IR35 do actually want those rights because they feel that they're being taxed in that way, and they should have them. Now, unfortunately, it doesn't matter what they want because they don't unfortunately get those rights, and that's kind of outside the scope of this legislation. But it's just worth echoing that point, and it could be that some clients who have inside IR35 contractors might want to look at, do they want to have them on a fixed term contract basis so that they do have more rights rather than as a contractor that's inside IR35. But I think I'm digressing beyond the scope of this webinar with that train of thought. But yeah, the other thing that was interesting in what you were just saying is the kind of upward pressure from hiring managers. So my understanding of how your organization works is that you provide sorry. So something to me mid-flow. Anyway, so a number of those contractors have been there for a while. They were kind of needed to the business, and and they were essentially overruling the IR35 determinations. They were talking to kind of someone else further up in the hierarchy, and it was being overruled. And this was creating a massive risk for this public body. And to be honest, the public body should have known better. And anyway, it happens, and there's this kind of, it causes so much bad feeling amongst contractors who've previously been outside IR35. They're now essentially losing income that they would have had previously, and they would have done their tax return at the end of the year. So it's not like they weren't paying tax, but yeah, for them, it's a massive change, and it just causes so much unrest. And I did have a statistic for people on the call, which is that the vast majority of contractors, so it's around 80% of contractors found inside IR35 are wanting to change clients, and they're actively looking for new clients because of the ill feeling that's kind of going on. And I can talk a bit more in more detail about that, but I feel like perhaps I've kind of said enough for the minute, but I can chat about it for ages, about the worker side.
Yeah, you know, Julia, if you wouldn't mind, because oftentimes, you know, if you're the end user or the enterprise that is engaging the workers, you know, you need the workers to do a specific task or project for you, and you're really concerned about getting the work done. And for intermediary companies, and I see some of our partners on the call too, we're really concerned about making sure that the governance and the compliance is right. And oftentimes, I don't think it's a deliberate thing, but the workers' view can be overlooked. I mean, from the, you know, as a champion of independent work, but particularly of independent workers, Julia, what's the consensus view in relation to how IR35 is generally being handled by the end user or the enterprise?
I would have to say, in generally, it's being handled really poorly, and that is a sweeping generalisation. But obviously, I hear about more of the poor situations because no one contacts me to tell me it's all going well, right? So yeah. But my view is that clients are not on top of it from the calls I'm getting, and I'm getting a lot of people getting in touch wanting to know how to challenge an unfair inside IR35 determination. And I would say what makes the process good from the contractor's perspective is good two-way communication and being listened to and having their individual circumstances taken into account. Now, I appreciate that might be impossible for some businesses that have thousands of contractors, but that is the ideal. That is the way that you will retain the talent. And if they are valued and part of the process, then if they do end up with an inside determination, at least they've been part of it and they can understand how that conclusion's been met. But the real problems are where it's just kind of almost slapped in front of them, you're inside IR35, and they feel like there's nothing they can do about it. Then they feel unvalued. Then, of course, they want to change clients. And the other point just to make on that is don't forget that contractor communities are very well established, and they will very much talk to one another. And so if you've got a disillusioned contractor at your firm, there's no way they'd be recommending to anyone else in their sector to work for your business. So there is that reputational side of the equation that I think sometimes businesses forget, because obviously you're focused on financial risk, but there is that side to the coin as well.
Yeah, and Julia, I just want to pick up on something you said, if I may. The retention piece, I think, has become ever more critical if you look at the war for talent and the talent scarcity globally. And I think when we started the webinars last year with yourself and Gareth and some other speakers, I think we thought with Brexit, the workers would essentially be captured within the UK and they wouldn't really be able to provide their services anywhere else. But of course, the pandemic and the remote working movement has really disproven that article. And there is the ability now to work anywhere or hire anyone anywhere compliantly. And therefore, UK PSCs now have the opportunity to provide their services, I guess, in other jurisdictions remotely, right? Which makes it ever more important to get IR35 right in terms of protecting your organization, but also allowing or ensuring your organization to retain that talent. Because the power, in my view, at the moment, because of the talent scarcity, is now with the workers. The workers have, if you're niche or in demand skill set, you've got the power as the worker, right? It's the great rebalancing. I don't think it's a great resignation, as Forbes and others have put it. It's really about a rebalancing of power, and the workers now have that power because of the trend for remote or working anywhere. But I suppose that's a more esoteric point that we could devote a whole webinar to, but it was just interesting, the retention piece, and I think that is a really critical point to make. So Julia, thanks for that input. Gareth, over to you, because I know you work with a lot of, and on a no names basis, of course, large and medium-sized enterprises. What are you finding in relation to the problems and challenges within your client base?
Okay, so lots and lots of issues. I think an awful lot that Julia spoke to there resonates with the issues that our client base are facing. And by way of example, there, the Road Haulage Association are saying that there's a 100,000 HGV driver shortage in the UK at present, and that the IR35 change is one of the most significant contributors to that. Yes, pandemic, yes, Brexit, but to see the IR35, which is an unforeseen outcome by the UK government in terms of introducing what on paper was a slight tweak to existing taxation legislation, but it has kicked off all these very significant issues. And fundamentally, the question that keeps coming back is, if a contractor who is and always has been paid and is responsible for their own tax, independent of the end user, is now going to be put onto payroll and taxed in a different way. So fundamentally, there's less money in their pocket. Why would they continue to provide services to that entity unless they can shift the contractual allowance or the rate of pay upwards to cover this new taxation change? And that creates difficulties all around. And that's one of the queries that keeps coming back over and over again. We're seeing the IT sector really struggling in terms of getting sufficient personnel in to hire the right contractors for certain purposes, etc. Again, IR35 being highlighted as a significant issue there, and it's driving costs up, and it's driving a wedge in relation to the employee, or E, and again, I keep using that with a small e, the relationship between the parties is becoming more difficult and fraught, especially whenever HMRC and IR35 has introduced this concept of end user liability. You know, whenever that arises and there's a concern, everyone seeks, especially when they go and see a solicitor, everyone seeks to try and pass that liability and make sure it lands elsewhere. And that's a very unhelpful and disconcerting point for the relationship generally. But one of the real frustrations, I think, with this is whether or not one accepts that it is the law and it is the law, therefore off we go, is the unreliability of the CEST tool. And CEST is catchy for checking employment status for tax. And this is a tool that has broadly been created by accountants. I think, no disrespect to accountants, but they're approaching this concept purely from a tax perspective, and they ask a series of fairly binary questions to try and work out what taxes to be paid. And that is fine as long as it is only a tax tool. But whenever it seeks to try and acknowledge employee status, what it has ignored is like 150 years of case law jurisprudence to try and work out what in effect is an employee. Most employment lawyers recognize that that's a very difficult concept in any event, because no matter how you label an individual, the actual factual reality of it is to be discussed and is frequently to be addressed at employment tribunals up and down the country. So when you have this thing which everybody defaults to, or originally from April onwards defaulted to be the HMRC government approved source to assist, and then when you actually work that through and discover that that is unreliable, then that puts everybody in a very difficult situation. And when I talk about unreliability, it's not just anecdotal. Even HMRC have confirmed that since April, when CEST has been used by the external user, and it's been used just over 1 million times as per these figures, in 210,000 cases, the CEST tool determination was inconclusive. So 1 in 5 cases, or 1 in 5 users of this, are coming away from the official government approved system and acknowledging that it is inconclusive and unhelpful. So if the CEST tool is unreliable, we say it has to be, and HMRC acknowledge that. But where does that leave people? And where does that leave end users whenever they are having difficulties with contractors who they've worked with for the last 20 years and whose skill set they absolutely need to deliver a service? There are enough problems here in dealing with supply and demand without having a taxation issue, which causes a rift between parties. And funnily enough, as of 27th of July, so only 3 or 4 months into this new regime, the government has issued a whole suite of additional support services in theory. And one of those is an employment status manual, which is to be read alongside the CEST tool. And in theory, that is going to help end users work out where the liability is and how to approach IR35 changes. So a bit of a mess, I think it's fair to say. And so many of our clients, corporate clients predominantly, but sometimes it's the contractors themselves coming to us and saying, well, this is very clunky. We're not sure how to navigate it. Can you assist? And one little interesting subset of that is we gave advice to a client in relation to how to interpret IR35 post-April. The client made their status determination assessment. They followed their workplace audit. They sent that information in. HMRC came back and said, actually, we disagree. You have misapplied IR35 in its new guise, and there's a potential fine and a penalty coming along. So the client quite rightly rang us up and said, Gareth, I think you've got this wrong. We're in trouble. I had a minor heart attack whenever I read it all, and then went back and thought, goodness, if I got this wrong. Went through it, was satisfied with actually all the advice we've given. And what we did was we contacted HMRC directly. We spoke to the individual who had made this analysis, and it became very clear to me and my team that a lot of people who are actually seeking to opine in this and apply this have not been properly trained on it. So what actually happened was we explained the rationale. We worked through the system within IR35 and the legislation, and effectively they stepped back and said, actually, you're right, fine, no further action, and the status determination stays as was. So what that illustrates is even if you get into it and navigate it and you do your workplace audit, your status determination assessment, you take external employment legal advice, you apply it, you may still have to push back fairly hard at any comments which issue from the various government departments that are tasked with running this, because I don't think their training is up to speed yet. And you should be pretty confident in doing that, and don't necessarily take any determination issued by them or any criticism issued by them about our determination or assessment. Don't take that as gospel truth, challenge it, because anytime we've challenged it, they have backed down. And I think the reason why they're backing down is because the legislation is poorly drafted and a lot of the outflows of this haven't been properly considered. That broad brush, Connor, is all I would say in response to that.
I tell you, Gareth, you've hit a number of points there that absolutely shock and surprise me. I think that the statistic you give that essentially 1/5 of determinations were inconclusive, that absolutely staggers me, but it proves, at least in my mind, and I'm sure some of our audience, that the CEST tool is not fit for purpose, as many people have commented on and suspected. That's point number one. That scares the hell out of me, right? Point number two is that the training within HMRC, given the use case that you've experienced and others, does not seem to be fit for purpose. So we've got these dual problems as I see it. The tool that organizations are using as the de facto government sponsored tool does not work, right? So in the event that that gives an inconclusive result, Gareth, what is the remedy or defense for an organization? How should they approach that, right? If you can answer that in a second, but the second problem is that training problem that you identified and mentioned, right? That's a real difficulty and will add additional uncertainty to end users, but also increase the complexity. Imagine, you have to do that 1,000 times in one enterprise. I know it's unlikely, but it's possible. So, Gareth, just to go back to my question, if the SES tool gives an inconclusive result, how should an organization best approach that? How can they defend themselves or mitigate that risk?
Okay, so I actually think that anybody who listens to this and who listened to the previous webinar on IR35 will probably know the recommended step plan to this. And I think that starts with a workplace audit. The workplace audit needs to be undertaken probably by a combination of management. You can't be, this has to be done on a bespoke basis because everybody has different roles and functions and personnel, but certainly operations, payroll, HR, and we need to have a real good walk through everybody that we pay regularly and irregularly. And you need to do that with external advisor, whether that's employment or finance. I'm not going to say you have to see an employment lawyer for this, but you do need to find someone who actually understands IR35 and the changes as opposed to someone who plays at it. And you need to sit down and do that sift. That is your first line of defense, actually, because it's a proper understanding of the legislation as it changes and your organization as it sits within the context of that. And then you do the workplace audit, you communicate, as Julia quite rightly says, and I'm completely on board with her on this. You never do this in a vacuum. You do this open comms with everybody that we may be identifying as potentially at risk, because you want to see their perspective and input as well. And you can listen to that. You're not necessarily bound by it, but I would certainly not ignore it, because their external accountant who's advising them may also have an opinion or a fact or a piece which slots into the mix, which helps you in making your assessment. And then we make our status determination assessment, we communicate that, we record it, etc. That is our step plan, and I think everybody should be doing that. And if we haven't done that, then we really should start. Because if you haven't done that and documented it with your rationale, then when HMRC does come knocking, we have nothing really to address and to deal with that. And as part of that process, by all means, use the CEST tool. That is also bizarrely one of our lines of defense in this, because HMRC recognize that it is unreliable. So if we have used that and it so happens that the determination kicked out by CEST is either inconclusive or it actually is supportive of our stance, great, have that, keep it. It's not a complete defense, but it is going to be a partial defense, because it illustrates we have sought to avail of even the government approved resources, even though we all know they're to a degree fallible. And then you overlay that CEST analysis with an employment analysis. And one of the big pieces in the equation missing in CEST is mutuality of obligation and an understanding of what that means in the employment context in relation to the user and the contractor piece. So when you have all those put together, that is actually how best to defend. And that is your reactive defense, because it illustrates your rationale. There is a proactive piece as well, which is if and when anyone HMRC raises the flag and says, well, actually, we think you may have carried out an incorrect an assessment, that's where we go really quite aggressively at it and just say, well, look, we have a rationale, which I've described as reactive. Let's look at this and let's challenge your analysis, because we know that at least in the short term, some of the people who are providing this opinion have not been properly trained. So if we can navigate that for them and bring them along the pathway, that is your best line of a joined up defense to all of this. And I know it's a frustration to say that CEST tool by in and of itself is not sufficient. Augment that with other things. And yes, we do have to spend time and money with external advisors. We have to consider what mutuality of obligation and employment tests are. But that's your defense, Connor. And that's what really, in the short term, until the legislation is tidied up and everybody falls into the better way of practice in this, that's really what we have to do.
Gotcha, Gareth. And it's very similar, I suppose, to the defense file concept that emerged in the USA when they brought in similar legislation around contractor classification or misclassification. And I think organizations just need to get used to this new normal of building out that evidence and that defense file. Julia, any thoughts on what Gareth said? Would you agree with the approaches that he mentioned? And also, would you add to that?
Yeah, certainly. We're finding that that using a blended approach works. So don't just take the HMRC's tool, for example, at face value, particularly because it does have the glaring omission of mutuality of obligations. So kind of a blended approach is working well, and certainly document everything. And really, you need to be able, as a business, to kind of prove that you've taken reasonable care over these determinations. So to do that will vary really on the size of the business, but the more ways you can back up your conclusions you've made about whether contracts are inside or outside IR35, the better, because there is this requirement to take reasonable care. And I know we've touched on a couple of times HMRC's tool and the recent cases, and I did just note down earlier the Home Office, which was fined £33.5 million for incorrect IR35 determinations. Of that, £4 million worth of that total was due to carelessness on the part of the Home Office, and we don't know exactly what that carelessness was. It could have just been their own teams trying to navigate HMRC's tool and not having sufficient understanding to do that to the appropriate level. It could be that simple, or it could be a lot more careless. And the reason why I mention it is because when we were talking earlier about this kind of pressure potentially for contractors to be found outside IR35, perhaps inappropriately, then you do need to be wary that there is precedent here for HMRC fining for carelessness, and so yeah, just be careful and evidence as much as you possibly can would be my advice.
Yeah, I think it's certainly, I mean, I'm feeling the SWOT test, but I think you can't under communicate this. You can't over communicate it enough. You can't be prepared enough. You just need to do your due diligence on each and every worker and have that approach that both you mentioned, Julia, and Gareth mentioned. Well, one of the things that also boggles my mind, I know I've sort of talked about mind-blowing, staggered, mind-boggling, and I'm sorry that might seem very negative to our audience, but recently I had a Fortune 100 client, right? So they've got significant UK operations and people, and they called us up and they essentially asked this question: can we opt out of IR35? And, I felt really bad because I felt, my goodness, we haven't done our jobs correctly, right, in terms of educating our clients, whether around this whole legislation. But let's say you are an organization and you've got to the end of your bloody tether. You don't want to use CEST. You don't want to use an external consultant. You don't want to use Gareth's law firm. You don't want to engage Julia or a whole host of other consultancies operating in this arena. There are others, but of course, this group is excellent. But say you don't want to do that and you just go, right, I've had enough of this. We don't want any PSCs in our business. Is there any legal problem or issue with just saying on a policy basis, we no longer will engage PSC workers? Is there a legal detriment to that, Gareth or Julia, that you're aware of?
Well, to my mind, no, but I'll be interested to be corrected if I'm wrong on that. But we did see some decisions being made on this basis, and obviously contractors that were previously working through their own limited company at large organisations were very angry that they were kind of now being shoved out and decisions made that personal service companies, as in Joe Bloggs Limited, were no longer viable for that business. But but they were saying that it's a policy decision. So it was nothing to do with off-payroll and IR35 legislation. It was a policy decision about how they engage their kind of services of individuals. And so yeah, to my mind, there's no legal reason not to, apart from obviously it caused massive problems. And actually, some of these firms lost huge amounts of skills and talent that they needed as a result, but that will have formed part of their decision. And so far as I'm aware, that's a decision that firms are able to make should they want to. But I urge caution and to really think about the impact of that decision.
Thanks, Julian. Gareth, any thoughts on this question?
I don't think there's any significant problem in adopting that policy, broad brush. Where you might have certain claims arising as individuals who have worked for an organization for significant periods of time and say, well, you owe us different kinds of duties here under contract, common law, etc. But those will fall to be addressed in individual case-by-case circumstances. What I have seen and been working with a US client on is a US client saying, well, we don't really want to have to do all this status determination assessment piece with international consultants based in the UK. We were just going to find an alternative consultant in some other country. And it's a real shame for the individual, it's a shame for the relationship, but we just don't want to touch this. We don't have an outlet in the UK. We don't want to be bogged down in some foreign jurisdictions, domestic tax arrangements. That's a shame. But we're going to find and source alternative contractors elsewhere in different jurisdictions. Because we're based in Ireland as well, the conversation then very quickly changes. Do you have any difficulty, or can you source this kind of contractor service provision for us in the island of Ireland, because they have a different tax regime, but at the same time zone, same background, blah, blah, blah. And that's a real shame. That's another inadvertent impact of IR35, which is something we have to be aware of. And everybody in this call will be aware of that if we work internationally.
Yeah, I think in the rush to essentially collect tax pounds using IR35 inside IR35 workers, there's been a whole series of unintended consequences. And some of that is that the tax revenue that they might have been expecting is actually a lot less for the reason that you just mentioned there, Gareth, which is such a shame for UK business and the UK exchequer. So guys, just looking at the case law, as I understand it, and Gareth, I'll probably defer to you on this, there hasn't been much IR35 case law post this April go live approach, but Julia mentioned an interesting case from the UK Home Office there. But also, Gareth, I was hoping you could speak briefly on the recent Department of Work and Pensions case, where I believe there was an assessment in the aggregate over a 3-year period of around £89 million in back employers' national insurance contribution and also some interest. I'm not sure if there was a fine or a penalty in there, but would you be able to give our audience some insight into what occurred there, Gareth?
Yeah. So Department of Work and Pensions, which is a government body, was fined 87.9 million for incorrect assessments of IR35 status of contractors. This has been in the public sector since 2017. So DWP were making their assessments since 2017 onwards, and whenever the case was assessed, the errors in their assessment process went all the way back to day one, 2017, all the way through. And one of their defenses was, well, we relied exclusively on the CEST tool for those determinations. And even though that was recognized as fallible, that was no defense as such. Now, I would suspect, because it's a government department funding another government department, there will be an appeal of sorts, or there'll be some kind of revision of the finance, or being cynical about it, the finance itself is cyclical. So it's not something that is going to be necessarily applied into the private sector when we see the case law on this. But I do think it's fascinating to see reliance on CEST tool was insufficient, and the fine is huge, almost 90 million sterling for historic issues over the last 4 years. And funnily enough, some of the guidance that came out in that, in the judgment or the guidance was, while CEST is free, comment is, you need a general understanding of employment status to ensure the answers provided are correct. So there's a total recognition there that CEST is only one part of the equation. Blind reliance on CEST alone, even if it turns out an answer as opposed to an inconclusive answer, is not going to be satisfactory as line of defense for any one entity, public or private. I think that's one of the real lessons to be learned out of that case, Connor.
And I suppose in summary, the CEST tool is not a get out of jail free card, I think is the best way to describe that, Gareth. Hope you don't mind me putting words in your mouth. And if we can, but before IR35 went live and shortly after this year, there was a lot of talk from respected commentators in the media that HMRC would apply what they described as a soft landing to private sector organizations or companies. Julia, question for you. Is HMRC to be believed?
I think as a general rule, being cynical whenever you see or hear anything from HMRC stands you in good stead, to be honest. Yeah, so the soft landing, I think they are genuinely wanting, or I think what they are saying around the soft landing is a genuine kind of aim for them. So they don't want this legislation to cause massive problems for businesses. However, particularly in the context of pandemic, etc. However, it is, and they can't ignore situations where they believe that there is non-compliance, particularly deliberate non-compliance. So they are trying to balance soft landing whilst also doing their enforcement work. And to be honest, anyone listening to this thinking, oh yeah, there's a soft landing, then I don't need to do anything right now, I'm afraid I would say that would be a misguided view at the very least. And if you are listening and you haven't done anything in relation to being prepared for this change, and this change came in April, so it's 5 months old, you must get on with it, because do not rely on the soft landing, because in all honesty, I don't pay any heed to it myself, in my view.
Yeah, I think that's a good rule of thumb, Julia, when we've seen some of the issues around the loan charge and various other things that I know you've been commenting and speaking publicly on and campaigning about over the years. Gareth, same question to you. Would you share Julia's view on this matter?
Yeah, I would. I love the suggestion of the soft landing. I think the way it's actually impacted it, the whole thing is more of a crash landing since April. So many unforeseen and negative outflows of this, mostly because the legislation at the heart of this and the CEST tool that is supposed to assist are unreliable. Now, I do think that is one of the reasons why they said there would be a soft landing. They acknowledge that their tool is not a one-size-fits-all, and moreover, there are employee issues, and employment status has always been vexed in the UK for a number of reasons. And I think that's why they talked about the soft landing, i.e., it would not be a hard and fast binary response to potential breach. But the other piece to that is, while there's a degree of common sense in that approach, what I would say, and to echo Julia's point in this, is absolutely right. A soft landing or a soft prosecution landscape for a situation will only be unlocked for an end user here if they have genuinely tried to do something about it. Burying the head is not an answer. That there will be no soft landing for that. Seeking to ignore the issue is not going to give us a soft landing. Trying to contract out of IR35 or to pass the liability on to a third party is not going to work. You have to do everything we can to work with the new legislation. If we ultimately are on the wrong end of a prosecution, the only way to achieve a soft landing or a soft prosecution, if you like, and a mitigated outcome, is if we can illustrate that with the best will in the world, we engaged absolutely with the legislation, we engaged absolutely with the CES tool, we augmented that with X, Y, and Z, whatever X, Y, and Z may be, whether it's your auditor, your financial services provider, or legal, it doesn't really matter. But if you can illustrate that you did everything you could to properly understand and navigate the process, as well as communicate openly with the individuals who, the PSCs and the single person corporate vehicles, then you have a good chance of resisting a challenge. But that does require an awful lot of spade work. And I think that's what they meant by the soft landing. I think you would like, or rather you would like to think that the inconsistency and the latest guidance having to be issued in July to try and clarify some of the inconsistencies might suggest that they will not be hot and heavy in prosecutions. But I wouldn't be so sure about that. And to borrow an example from another piece that we're working with of relatively new legislation in relation to furlough, we are already seeing cases coming out which have made it through the employment tribunal process in the last 18 months of furlough, where an employer has failed to consider furlough or apply it, and that is inherently unfair. So when those get in front of a tribunal judge, we're getting fairly binary decisions. And that, in each case, is where the employer buried its head and chose not to do something or properly consider it. So there has got to be an engagement with this legislation, and there's got to be a genuine attempt to navigate it. If we do that and still get it wrong, you have a chance of availing of the soft landing approach. But if we don't address it at all, no chance whatsoever. Very binary outcome when and if we get to prosecution levels.
I think Gareth and Juliet, some smashing advice there for what seems like a relatively simple question. So thank you for that. And I think, just thinking out loud here, I think it's maybe worthwhile we do a webinar on furlough and some of the impacts around that, because we've seen cases around holiday pay and annual leave, and not just the items you mentioned. So I'd love to get you guys back on that, and we could talk about that in a bit more detail. I think that would be fascinating for a lot of the enterprises and intermediaries out there. So I know we've talked about this during the course of the webinar, but I want to leave our audience with some tangible steps that they can take. If they haven't started IR35, they're considering it, they want to improve it, they just want to do it right. So Julia, I know you've mentioned this and Gareth has, but just to help our audience before they leave, is there some steps that we can carefully outline to get organizations ready or prepare better to navigate IR35?
Yeah, so one of the first things I would look at is clarifying your team that's working on it and who is ultimately responsible for it. So for some organizations, that might be the finance director, it might be HR, it might even be procurement. There's kind of all these different bits of an organization that kind of feed into this process. Now, the reason why you need someone who has ultimate kind of responsibility, and I would say you do have to have that individual who is known and kind of named as such, is that situation where you're getting that upward pressure from others, and actually you need an informed decision on the taking into account on behalf of the organization, what's the risk here, who's going to make that decision, and then once that decision is made, it doesn't get changed, you know. So and that's kind of after the kind of process whereby so the legislation has a process whereby if someone is unhappy with the determination, then you as the client need to go through a process to kind of make sure that you've looked at everything properly. It's kind of like an appeals process, but not because it's internal. Anyway, don't want to digress too much on that, but for me, I was so astonished with that organization that had people overruling other people just because of who they knew, really, in my opinion, within that organization. And that cannot happen because there are financial risks to this legislation, and so you need ultimate kind of sanctions to be signed off by someone with a suitable responsibility level. So that would be my one piece of advice if there was only one.
Thanks, Julia. Gareth, we'll open the call for questions in 1 minute, but anything to add on that, just within a minute or less?
Minute or less. It's a 5-step plan, Connor. One is putting the team together: payroll, commercial or operations, legal, HR, finance. 2, workplace audit. 3, make your initial assessment using CEST++. 4, communicate your provisional status determination assessment. Listen to feedback. 5, apply. And if there's an appeal in there, that's what you do. 5-step plan. It's the best you can do.
Love it. Love it. Simple but effective, and I hope easy to implement. So does anyone on today's webinar, firstly, thank you, Gareth and Julia, for everything you've had to say today, and thanks for our audience and listeners. But is there any questions from the floor that you can put in the chat, or you want to address to the call directly? I don't think we have any fast typers. I don't think we have any questions. With that, guys, I think we'll bring today's webinar to an end. Thanks everyone who has joined and tuned in. And of course, thanks again to Gareth and Julia for joining. Have a great day, everyone. Really appreciate it. Thank you. Goodbye.